So welcome back to our study of shareholder rights. And right now we're talking about the shareholder right to sue. And as we learned in our last lecture, there are two ways shareholders can sue. They can sue in a direct action or a derivative action. And actually later on we can talk about how they can also sue in fraud actions, a separate course of action. But we're fundamentally going to focus on derivative actions for this lecture. And we're going to talk about what constitutes a matter for a derivative litigation. We had talked in the last lesson about the distinction between what is a direct suit, what is a derivative suit. We had used the Tooley two-step method to determine who was harmed and who would be essentially compensated for that harm as our effective two-step test to determine if it was more appropriate as a direct or a derivative litigation. We'll emphasize a little bit about that. And then we're going to talk about the fundamental procedural difference with derivative litigation, which is there is this demand requirement. What's the demand requirement? How do you make demand? And when, most fundamentally, is demand excused? Because actually making demand is a losing proposition. Directors are simply not going to sue themselves, and so if you ask them, pretty please, will you sue yourselves? They'll say no in most cases. So we need to have a different mechanism for effectuating shareholder rights through litigation. And so we'll talk about the demand excuse, which has, again, another counterpoint that demand might not be excused if it is more appropriate for the matter to be referred to a special litigation committee, or SLC. We also talked a little bit about the pleading requirements and how you get the information needed to plead with particularity. Well, shareholders can get access to information because they have certain rights to information. So those information rights are used and implicated here in terms of success in initiating derivative litigation. And there was a lot of consternation about whether shareholder litigation, in particular derivative litigation, was good or bad for the company, good or bad for society. And in 1995, the legislature addressed that. And so we're going to take a look at that as well. So with regard to derivative litigation, we have a couple areas which are the common subject matters of these type of jurisdictions. And so first, we find that the most common is going to be some type of usurpation of a corporate opportunity. And we're going to come back to this in the duty of loyalty. We're going to talk about what it means to usurp a corporate opportunity, but when the corporation has a right to an opportunity that the director becomes aware of by virtue of being a director, and then takes that opportunity for themselves. And instead of sharing that profit with the corporation, or in fact that the profit of the value of that transaction entirely inuring to the corporation, takes it onto themselves. We also find claims of waste, that a corporate director is simply burning the company's money, throwing it away. And these actually come up sometimes in correlation with corporate social responsibility initiatives. Some shareholders like them, some shareholders don't. And so if a director engages in corporate social responsibility, effectively does give money away, and we saw this last semester in the case of Ford, where Ford basically said, I'm charging less than I need to for cars in order to take money from the shareholders and give it to the people. That didn't go over very well. I wouldn't recommend using that phraseology. Most corporate social responsibility initiatives are at least rhetorically wrapped up in a message of improving corporate finance and adding value to the company. Otherwise, there could be a potential accusal of waste. Another problematic transaction is when a director is not necessarily taking a corporate opportunity for themselves, but is somehow interested in the transaction and therefore does not get the benefit of the duty of care. And we will see that more in our chapter on the duty of loyalty. And finally, poor corporate performance. Basically, whenever the stock price goes down, shareholders that are able to, or at least the plaintiffs' law firms that like to represent these type of shareholders, tend to race to the courthouse and sue. So poor corporate performance is our sort of fourth common category. So we see that usurpation of corporate opportunities, which is a subcategory of the duty of loyalty, waste of corporate assets, which falls under the duty of care, interested director transactions, which fall under the duty of loyalty, and poor corporate performance, again under the duty of care, are the four main subject areas that lead to a derivative litigation. And just as a reminder, these are distinct from direct litigations because those pertain to harms of the shareholders' rights that they themselves have, like their rights to vote or their rights to govern the corporation are impeded. These are then harms to the corporation. The shareholders are suing derivatively. So once we're in this world of derivative litigation, once we know that we're in a subject matter that is not that does not make direct action available, a harm to the corporation that the shareholders want to sue for, they have a requirement to make a demand on the board. In fact, the Federal Rules of Civil Procedure dictate that a complaint in a derivative suit has to allege with particularity efforts made by the plaintiff to obtain an action from the directors. So not only do they have to make a demand, but they have to actually allege in particularity that they have done so. Otherwise, the case cannot proceed. However, as we'll see in a moment, demand can also be excused. And in fact, it always needs to be excused because very infrequently do directors assent. If there's some effort made by the shareholder to get the directors to sue themselves, it rarely moves forward. So instead, we look at whether or not it's excused. Where do we look to the rule? Federal Rules of Civil Procedure, Rule 23.1, which, by the way, 23 is on class actions, so 23.1 helpfully co-located there. And that talks about the prerequisite that I just mentioned in terms of that pleading requirement. We also can find that in Delaware Court of Chancery Procedural Rule 23.1. So you can remember that Rule 23 is the rule for class actions, and 23.1 is the rule for derivative actions. Why do we have this requirement? Why do we require a suit on why do we require a demand made to the board before a suit could proceed? Exactly. The principle here is that shareholders do not run the company. The directors run the company and make all of its decisions. The decision to sue, it's a corporate decision. It's a business decision. So if the corporation is harmed and wants to effectuate its rights to have redress in the courts, that's a business decision. Why should the shareholders have the right to do that? That's the basic principle behind this requirement. Of course, shareholders resist this because directors will generally not comply and not listen to them. And so instead what they'll plead is demand excuse. So we have this demand requirement, but how can we get it excused? If directors are not capable of exercising an appropriate level of business judgment, then the corporation, then the demand requirement is excused. And there are a number of reasons why directors would not be able to exercise business judgment. The biggest one being that there is a substantial risk they would lose that case and be personally liable. Now, this is going to be a major paradox because, on the one hand, you might think that it's if a director, for example, as we'll see, has the ability to limit their liability through the methods we'll talk about next week, exculpation, indemnification, other limitations of liability. Well, that has a problem because now the director effectively is going to have all of that amount of damage paid by the company. They are not any longer, you might think, personally at risk of actually paying out money damages for failure. So by having these type of exculpations that we'll talk about, we'll see how that might actually make it harder to plead demand excuse because a director that has different mechanisms that protect them from liability thereby might be able to make a business judgment about whether the suit should proceed or not. And so when we talk about that next week, it'll be a chance to circle back to this requirement. In any event, the demand futility requirement is effectively showing that demand on the board of directors would have been futile. And the directors could not exercise their business judgment, and you have to plead this with particularity. And this could either be because the directors are self-interested, and we'll see that in the duty of loyalty concept. If a director is self-interested, the business judgment rule does not attach because there's a presumption that an interested director is not making a business decision or is not capable of making a business decision. Or we could show that the underlying decision is not the type of decision that requires a business judgment, which is harder. It might be easier, instead of just talking about it conceptually, to look at an example. So let's talk about the case of ARONSEN v. Lewis, which really has to do with Myers Parking, as shown in the illustration here. Anyone want to help with the facts of this case? What happened in ARONSEN v. Lewis? And what was the claim had a particular name to it. It's actually one of those 4 that I mentioned at the outset as a common subject matter for derivative litigation. What claim did the plaintiff put forth here? What did the directors do with corporate funds? Waste, exactly. Yeah, a claim of waste by offering this deal. So that's a pretty good understanding of it here. So we have, in this case, Leo Fink was the individual's name. He was the CEO and the director, and also, by the way, a 47% shareholder. So hugely influential, right? CEO, director, and 47% shareholder. And the board approved what we'll call a sweetheart deal. Gave him a really nice cash deal that gave him a really, you might call it a golden parachute, a retirement package that was going to set him up really nicely. And this package included an employment contract that allowed for indefinite employment. And as Joanne correctly pointed out, it was very hard to measure what he was supposed to do for all this money. He also got this contract for consulting and a number of personal loans. So that's a lot of goodies in his goodie bag here. Yeah, congratulations. Thank you for running this company. And here your friends are going to vote that you get a job for life, a lucrative consulting position, and some very low-interest loans. So, Lewis, in this case, is going to be suing the board members, ARONSEN et al. And Lewis, by the way, is a serial plaintiff, so the type of person that often is found suing corporations and directors probably is connected with some plaintiff's law firm, right, that knows that this guy owns $2,000 worth of a lot of different company shares. And he sues and claims that the agreement should be canceled because they were a waste. Just a pure waste of corporate assets. Why are we giving this guy any money? And Lewis further claimed, so we can see here that the waste claim is formative in this being a derivative litigation. The corporation, the directors caused the corporation to waste its money. Now the corporation has less money. So this is a derivative claim, all right? Okay, so moreover, we have to show in a waste claim that there is no valid business purpose, which, well, that can be hard, as we'll see. No valid business purpose. That's a very high bar. And Lewis, of course, did not make a demand on the board. Now, this board just granted this deal, and they didn't think there was anything wrong, or at least litigation worthy about it. So Lewis claimed that an attempt to cause the board to take an action would be futile, and therefore demand should be excused. And so did the court excuse demand in this case? Was Lewis able to proceed with his suit? So the answer was no, demand was not excused. Demand was not futile. Okay, so why? Why did the court come to that reasoning? The court held, our view is that in determining demand futility, the Court of Chancery in its proper exercise of discretion must decide whether there's a reasonable doubt created that the directors are disinterested and independent. So is there a doubt? Are the directors interested in the transaction? Are they so beholden to, it's a language that we'll see, beholden to think that they were not independent? And two, is there a reasonable doubt that the challenge transaction was otherwise a product of a business judgment? And they declined that. They said that no, that's not the case. Lewis's arguments were going to fail. He was not able to raise a reasonable doubt that the directors were not interested. Now this is a little bit odd maybe because, as I mentioned, this is a 47% shareholder and so hugely influential on voting for the board. I mean, with only 3% of other shareholders, provided he keeps the stock after leaving the company, he could overturn the board. And so you might think that this is grounds for suggesting the board is interested in keeping Fink happy. The board makes Fink unhappy, Fink votes for new board members, so are the board members really disinterested? But the court here found that there is a presumption that the board is independent. We begin with the presumption that the board is independent. In fact, these cases usually fail. So if you're going to guess one or the other, it's better to guess no, that the suit did not proceed, because they tend not to, except in case books where we do try to show you a couple illustrations where they did. So Lewis would have to allege particular facts, right? Again, we have to plead with particularity, additional facts that show that the presumption is not merited here. And he didn't do that. What would those facts look like? Well, we'll see that in some upcoming cases, most notably in a case involving Oracle. So Lewis argued the directors would be suing themselves, right? And since they approved the wasteful transaction. And if you're suing yourself, there's a presumption, Lewis reasoned, that you're not disinterested. You would not want to sue yourself. But the court found that this was a conclusory allegation and said, unless facts are alleged with particularity to overcome the presumption of independence and proper exercise of business judgment, in which case the directors could not be expected to sue themselves, a bar of this sort, a claim of this sort raises no legally cognizable issue under Delaware law. So what do we learn from this case? That actually it's a pretty high bar that the plaintiff has to pass to explain demand should be excused. And here, even though the directors seem like they might be bound up with Fink's happiness with them because he was a 47% shareholder, they just didn't, Lewis did not allege the level of factual support needed to get demand excused. So when is demand excused? Demand is excused when a plaintiff pleads particularized facts, not conclusory allegations, which if true would show a breach of the business judgment rule, whether that is the directors failed to become informed and therefore, as we'll see in Van Gorkum, are not privileged to the business judgment rule, whether they engaged in self-dealing and therefore are not able to take advantage of the business judgment rule because of self-dealing or being interested or in a conflict. And the complaint must raise a reasonable doubt that directors are disinterested. So it's really a strong burden on the plaintiff, and so demand is not excused lightly. Where would the plaintiff get this information from? How would they know that the directors are inextricably intertwined with the CEO such that the sweetheart deal shows that they did that because of being dominated by the CEO? Well, they can use their inspection rights. But look, inspecting the books and records may not evidence what you need. It's hard to prove these type of things or allege these things with particularity. But that said, you know, one thing that you might do as a shareholder is ask to inspect the books and records, and you can expect the board will deny that request. The board knows you're poking around trying to sue them, right? And so you make an inspection request because you want to put together a complaint that's going to survive. And so they deny the request for information. Now you have a fact that shows the directors might not be capable of operating their business judgment. So the usual step is you make the inspection rights knowing they'll be denied, and then you include the allegation that the inspection request was denied as evidentiary that the directors are not disinterested and would and that demand should be excused. And so that's usually the way, unfortunately, that inspection rights play out, although sometimes you do get some information. Yeah, Mallory. All right, so the other way that this plays out is the board can form a special litigation committee that will decide whether or not the derivative action can proceed. If the board as a whole is in fact or is worried that they would be seen as interested and not independent, they can appoint an independent committee to make the decision, and that should cleanse the issue. So typically the board will form an SLC when a derivative suit is filed, and they will investigate the claim and the complaint, and they will recommend to the court whether the litigation should proceed. In theory, this should arrive at an independent result. The SLC being comprised of, independent directors who are not defendants should be impartial. In reality, SLCs almost always recommend against lawsuits. There are questions that arise about structural bias and other types of issues, but when an SLC is present, it's even harder to allege demand excuse because now it is a theoretically independent committee, one step removed from the directors at issue, who is making that decision. Does it work? Not sure. Probably not. But, we're trying to deal with this rather complicated issue of the shareholders are not supposed to run the company. And so we have to provide some kind of avenue for an SLC to exist, and it's not clear if it arrives at the right result. All right, our case for this one was AUERBACH v. BENNETT. And again, recognizing that you read this for last week, maybe I'll just kind of go through this briefly. This case involved General Telephone and Electronics Corporation, GTE. And so General Telephone and Electronics shareholders filed a derivative lawsuit under New York law against GTE officials alleging that they had paid kickbacks, $11 million worth of kickbacks in 1979 dollars. And so GTE responded by forming an SLC. And the GTE SLC had 3 outside directors, and so these directors were not part of the allegations. No one had alleged that these 3 individuals had been part of those kickbacks. And so, at least theoretically independent, the SLC concluded there was no violation and the case should be dismissed. The shareholders, of course, appealed. What result? Well, the question here really is, does the business judgment rule protect an SLC's decision? And the answer in AUERBACH was yes. Yes. In fact, the business judgment rule protects the SLC much in the same way that it would protect the board itself. Why? The committee's substantive decision falls squarely within the embrace of the business judgment doctrine. The conclusion reached by the SLC is outside the scope of our review. To permit judicial probing of such issues would be to emasculate the business judgment doctrine as applied to actions and terminations of the Special Litigation Committee. Why did the court hold this way? This is what we'll call the pro-Special Litigation Committee approach. And we have 2 cases, usually got one on one side, one on the other. Very much in favor of the SLC. In this case, the court did not allow investigation. Why? Well, it said that there were no allegations that these directors were interested or beholden, and so therefore they're entitled to the business judgment. And again, going back to the rule that we saw in our first case, the allegations could have been raised that either raised questions about the disinterestedness and independence of the SLC or the adequacy of their investigation procedure. It did neither of those things. It did not claim that the directors were interested or beholden, or at least not to a level of particularity, maybe in a conclusory way, but not with particularity, and did not allege that the committee did not go through the appropriate paper and process. Paper and process will make more sense once we read the Van Gorkum case, where there was a failure of paper and process, but it seems like here the committee operated normally, and therefore their decision is final, and the shareholder is not going to be able to defeat their decision not to sue. Now, that's a very deferential approach. AUERBACH is the deferential approach to the SLC, pro-SLC approach. But we also have a case, ZAPATA. And ZAPATA Court versus MALDONADO came out a bit differently. So in this case, a shareholder sued ZAPATA Corporation alleging a breach of a fiduciary duty, and more fundamentally to this part of our study, that demand was excused because a majority of directors benefited from the transaction, directly benefited. So ZAPATA created an SLC, and this SLC had independent directors who were not allegedly beneficiaries of this transaction. Very similar facts to AUERBACH. And they hired advisors, they hired lawyers, and in the end they recommended for dismissal of the suit, because that's what SLCs do. They recommend dismissal of the suit. So are we going to sustain their decision? How should the court assess the SLC's recommendation? Well, here the Delaware court took a slightly more shareholder favorable approach and recommended a 2-part test. We all like 2-part tests, much better than 3-part tests, far better than 4-part tests. They're not quite as good as 1-part tests, but we have a nice little 2-part test. And it said, 1, the court should inquire into the independence and good faith of the SLC. Is the SLP independent, and did it operate in good faith? And 2, this is interesting, the court should balance the substantive nature of the non-frivolous claims against the corporate burden for defending them. So this opens the door much wider for shareholder suits, because now we have the second step where the court actually gets to balance how valid it thinks the claims are based on the complaint before any discovery proceeds. Now, this is interesting. The courts generally have a very deferential approach, But now they're really stepping in there and saying, we might challenge the SLC's decision based on allegations in a complaint with no discovery if we think that the claims are not frivolous and very substantive, and it would not be an undue burden on the corporation. The second step effectively asks the court to supplement its business judgment for the SLCs. And that's a step the courts don't usually make. But again, it puts a fine point on the tension between the need to have shareholder litigation and this principle that the directors run the company. So ZAPATA is a much more pro-shareholder approach. And it has this reasoning behind it, which will come to several times throughout this course, that there is a structural bias. Directors are all, going to the same country club, go to the same church, grew up in the same communities, all went to Yale, I don't know. But in any event, are all part of sort of a common class of individuals who are in cahoots with each other almost inherently. And as a result, we have some basis for questioning all of their decisions. They may not be totally disinterested. There's sort of a general structural bias concern of the influence of the directors who are at risk on the members of the Special Litigation Committee. Look, it's not too hard to imagine. I mean, the SLC was appointed by those directors. And so there's at least some first or second degree connection there. So we see that there are two major approaches. We have the AUERBACH highly deferential to the board approach, the pro-SLC approach, and then we have ZAPATA with a two-step test that actually invites the court to supplant the board's business judgment for the court's business judgment, asking how substantive are these claims and how much would it hurt the corporation to investigate it. And so courts today generally take an approach that's somewhere in between, but these sort of set the high and low watermark. So we do have cases where we have a very extreme deference to the board and cases where the court is willing to actually supply business judgment. Most Delaware decisions are somewhere in between, where the courts are somewhat deferential, but it has not been widely adopted to take this highly deferential approach. Showing kind of a range here. All right, so we also have a case that I think is illustrative about whether an SLC is independent. And so we have in the case of Einhorn v. Kulea, Kulea is the president, the manager, a director, and a majority stockholder of Northern Labs. And we got our friend here working for Northern Labs. He's really excited about his job there, and maybe he's also a shareholder. He's going to be upset when he's harmed. Einhorn was a director and a minority shareholder. And Kulea, who again was the president, manager, director, majority shareholder, came to the board and asked for a retroactive performance bonus. He did a really great job. He wants some money. And on top of that, the board consisted of his wife, who obviously would share in the marital, I shouldn't say obviously, I don't know their marital arrangements financially, but I assume that his wife stood to benefit from her husband's retroactive performance bonus. Einhorn, who obviously didn't like it because he's on the other side of the V. Mertz and Bonk. Shelley, Kulea, Mertz, and Bonk also comprised the compensation committee, and they would decide whether or not our friend and husband here would get paid. Einhorn filed a direct suit, which failed. Why? Why is this a poor choice for a direct suit? What is the claim here? It's a claim of waste, right? You gave this guy a retroactive performance bonus. You're throwing the money away. You're throwing the money away. So why does this guy get a retroactive performance bonus, right? The claim is waste, so it's not a direct claim. The shareholders only harmed derivatively because the corporation has less funds. So it was dismissed because it was improper. Consult the Tooley two-step, right? You'll see that it was not properly filed as a direct action. He refiled as a derivative action, and they formed a special litigation committee, which I think they had the good sense to not put Shelley Kulea on, the wife, but it consisted of Tuning, Bonk, Chua, and Beagle. All right, and these four folks got together and voted 3-1 to dismiss the suit. And of course, the question once again is, do we give deference to the Special Litigation Committee? was the Special Litigation Committee comprised of independent directors? And we have a set of factors that I'll mention for you here, and they're also in the workbook. A set of factors that the court goes through to determine Special Litigation Committee independence. And so now we have a multi-factor test which falls somewhere in between the highly deferential AUERBACH approach and the much more aggressive ZAPATA approach, a 7-factor test. 1, a committee member's status as a defendant and potential liability. That's a big factor, right? If you're a potential defendant, probably not going to be able to exercise business judgment, although exculpation, indemnification, limitations of liability might change that. A committee member's participation in or approval of the alleged wrongdoing or financial benefits from the transaction is a factor, right? You might actually be liable. A committee member's past or present business or economic dealings with the individual defendant, showing they might be beholden to that defendant. A committee member's past or present personal, family, or social relations. Most people don't like to sue their husbands. I mean, in a divorce. But, or if you sue your husband and not in that context, it might lead to that, right? So there's definitely an attitude of personal family members maybe not suing each other. So we can see how that would be someone who's not disinterested. A committee member's past or present business or economic relations with the corporation, the number of members on the SLC, and the role of corporate counsel and independent counsel are all factors the court will look at in determining if the SLC was independent. All right, true or false? Shareholders can avoid making demand on the board by suing all the directors, who then become interested by virtue of being sued. False. That would be far too easy. You can't win simply by suing all the directors, right? You have to actually allege with particularity that they would be unable to make a business judgment, and simply being sued is not sufficient. It may be necessary, but it's not sufficient. All right, true or false? Fink's deal, where it was unlikely the corporation would receive any services, was a waste. Nobody could say the corporation got its money's worth. That's also false. Waste claims are extremely hard to prove. They rarely prevail. It's very hard to say that there is no business reason to do something. No business reason at all. Look, you could make some argument. Look, it's going to keep him around for an extra week, an extra minute, an extra second of his incredible brilliance. Or it will illustrate to the next potential CEO that we're a generous company and we reward our people for doing it. There's all kinds of ways you could cook up a message. It's very hard to say a waste claim will prevail. True or false? Despite academics who claim there is structural bias, boards regularly decide to sue their own board members. No, they never sue their own board members. This never happens. I don't know if it's structural bias or what it is, but they're just not proceeding with these lawsuits. And finally, true or false, whether a lawsuit has merit is something that judges know better than directors do. And so there is no reason for judges to abstain. False. Right? The business judgment rule is a doctrine of judicial abstention, as we'll see in our next set of slides. And so we can apply the 7 factors, and so if presented with a question involving whether or not demand should be excused, on the one hand, you have AUERBACH, and you should, if there is a demand and a special litigation committee, and the SLC recommends dismissal of the suit, will the SLC's decision be honored by a court? How would you evaluate that claim? On the one hand, we have precedent in AUERBACH that says effectively the SLC always prevails unless they're obviously interested, and you have pled with particularity that they are not capable of making a business judgment. You have a precedent really on the other side saying the court will weigh how meritorious the claim is versus how expensive it would be to conduct the litigation. And then we have Einhorn, which presents a 7-factor test. And so all of those are relevant case law in whether or not a court will dismiss a case. There are some procedural requirements that I want to address very briefly, known as adequacy and standing. Adequacy is relatively easy to provide, and these are, by the way, coming from the Private Securities Litigation Reform Act of 1995. Adequacy is the idea that a plaintiff is able to represent the interest on behalf of whom the suit was brought. And it's usually completely a non-issue so long as you have an attorney who does derivative litigation as your plaintiff's attorney. So long as the shareholder does not have obvious, like, again, this is a derivative suit, so the shareholder is suing for or causing the corporation to sue. So if the shareholder has obvious conflicts with the corporation, that can be an issue, or if they're representing themselves pro se, that could be an issue. But effectively, that rarely comes up, and so adequacy is almost never an issue. There were some early cases that related to whether or not a plaintiff was sufficient. We have, this was Inri Fuqua Industries, and in this case we had Miss Abrams, and she was a plaintiff, and she was elderly and suffering from memory problems, so not like your world's best plaintiff. And we also had Mr. Freeberg, who was, I think, hanging out in South Florida, with a very few shares and had a very insubstantial recovery and was put on the stand and knew almost nothing about the lawsuit. So are these plaintiffs adequate? Yes, they were. These plaintiffs were adequate because, quote, a representative plaintiff will not be barred for the courthouse for lack of proficiency in matters of law and finance or for poor health, so long as he or she has competent support from attorneys and advisors and is free from disabling conflicts. In other words, adequacy is very, very easy to show. Plaintiffs do not have to have any type of substantial knowledge, but if they are representing themselves pro se or if they have a disabling conflict, that's an issue under the law. Standing is a little bit more complex. In order for a plaintiff to have standing, they actually have to own the stock at the time when the harm occurred. They have to own the stock at the time of the wrongdoing. They have to own the stock when the suit is filed, and they have to own the stock throughout the entire pendency of the litigation. Now, why is this? Again, this is a person that is suing on behalf of the corporation. So they had to be part of that corporation when the harm occurred. They have to be part of that corporation when the lawsuit is filed, and they have to maintain that holding of the corporation throughout the pendency of the litigation. So standing can be a little harder. There are some corner issues about whether the stock is owned in a plaintiff's street name or through an institution. But I'll just leave it with those three factors, because I think that's all you really need to take away from this, that it does provide an additional procedural hurdle that shareholders are going to need to have their stock. Shareholders that want to make a derivative action have to own their stock at the time of the wrongdoing, when the suit is filed, and throughout the litigation. The other concept is a disabling conflict. And so if the shareholder owns a substantial amount of shares in a competitor corporation, potentially, as a case of Dodge v. Ford and things like that, if the Dodge brothers were trying to commence a derivative action causing Ford to sue itself, and they stood to benefit substantially by essentially destroying their competitor, that could be the type of disabling conflict. It is a huge risk, and the standing issue and the requirement of holding those shares through the pendency of the litigation is a huge cost. And in fact, the shareholder is almost certainly going to drive the stock price down. As soon as that suit is filed, it generally results in the stock price going down almost immediately. And what you often find is the shareholders that make these suits often only own a small amount of shares, and you have to have some real questions about whether or not these actions are taken to benefit the corporation. That's one of the reasons why people are not sure derivative litigation is such a good idea, and might explain why the AUERBACH approach has held sway as much as it has, because courts are very skeptical when you have a plaintiff with $2,000 worth of stock if they are really commencing this lawsuit in order to benefit the corporation. Futures are different because futures you don't actually take possession. The bigger issue is with short selling. And so there are some more complicated issues. In terms of having a futures contract, you are not a shareholder. So that one's easier, because a futures contract means you have the right to purchase the shares in the future. You have an option, effectively, but you don't have possession. You're not a record holder. So to sum this one up, the ideas in this chapter were effectively that subject matter of derivative litigation, primarily we see waste as our number one claim that is often raised. We also have usurpation of corporate opportunities and interested director transactions on the duty of loyalty side of the equation, and then back in the duty of care. Any type of poor corporate performance often invites a race to the courthouse, and these shareholders might sue. The demand requirement is a huge burden, It's necessary to distinguish between what shareholders do and what boards do, but it's a big obstacle that needs to be overcome, and so the idea is to seek excuse so that you're not, in fact, subject to the demand requirement, but that involves pleading with particularity facts that show demand futility. And this is even harder where a special litigation committee has been compiled, because they're at least ostensibly disinterested. And we do have different viewpoints on how much deference we give to these committees. We have a very pro-deferential opinion in AUERBACH. We have a much less deferential opinion, effectively a evisceration of the business judgment rule in ZAPATA. And we have Einhorn v. Kulea, which at least provides a 7-factor test, which suggests somewhere in the middle of the road where most courts come out. How do you get some of the information you might need? Inspection rights are an avenue for that. And don't forget, just kind of a, not quite a footnote, but a procedural requirement for adequacy and for standing in order to sue. And so that is derivative litigation. Any questions?